COIA, Conflict of Interest Act, known to us that know and love it as COIA. There is a lot of peril if you violate it. Now you may say, oh, that just relates to elected officials. I don't need to worry about it. Not so. There are certain issues that either you must file a disclosure on because you're one of those people named by your local government, or there may be a situation, a transaction comes up in which you have to disclose the fact that you might have a conflict. What are the premises of COIA? 3 things. Really easy to remember. Don't take bribes. Hopefully you know that, but anyway, you tell people, don't take bribes, don't use your influence for financial gain, don't participate in prohibited contracts. And there is a list of prohibited contracts that are in the state code under the COIA. If you ever have insomnia, read the Conflicts of Interest Act until you fall asleep. It should take you about 2/3 of it. The other 2 things we'll get to in a minute is if you have a conflict, you may have to disclose, and there are certain rare instances where you may have to disqualify. Virginia is very simple. No bribes, disclose, the electorate will take care of you if they don't like your personal interest in conflict, or in those rare instances, disqualify. Local officials, employees, those employees who are specifically designated by the governing body or in the statute, that often includes the planning director. It does include definitely your planning commissioners, have to file a disclosure form of their personal interests and other information. And that other information will be what I'll call transaction-based. It will be when specific things come up. Importantly, that has to be done every year by January 15th, in addition to those specific transaction forms you may have to file. Importantly, the clerk to the Board of Supervisors or to the City Council who collects these forms often is not your mother. So don't expect that that person is going to do everything for you in this regard. Most of them are very kind and they remind you if you have responsibilities. The linchpin of the Conflicts of Interest Act is called personal interest, and it's specifically defined by the code. It includes the official or employee, their spouse, whether or not they're in the same household. So if your planning commissioners or you are covered by a particular, you have an interest, and you have somebody living outside the home who is your spouse, it still counts. However, if the person's not your spouse, doesn't count. Anyway, we'll get to significant others at some later point, because actually the question does come up from time to time. And dependents living in the same household, so that would be like children or grandparents, where more than half of their support comes from you. Okay, examples of what has to appear on the annual disclosure forms. Again, we're talking about personal interests. If you go to the state code or you get a copy of these forms, there are like 10 attachments to it, and you go, oh my gosh, this is worse than filling out my taxes. So remember again, the personal interest is the immediate family, and how do you define it? You define it monetarily, and that is ownership in real and personal property, and usually it's going to ask you, do you own property in the same county or the same city in which you have your position or the planning commissioners have their position. I'm going to primarily focus on you or planning commissioners. We know it also applies to the Board of Supervisors and a whole host, city councilmen, a whole host of other people, for those of you in towns, town councilmen. But to avoid my sort of saying those 3 things in seriatim real fast a lot, I'm going to primarily refer to you in planning commissions. And then the ownership interests have to be in excess of $10,000 or 3%. There are also liabilities. So if you have debts or your planning commissioners have debts, if it's more than $10,000 or 3% interest in it, there could be a problem there as well that needs to be designated as a personal interest. I used the word problem, that was a bad use of terms. It doesn't mean you're illegal. It just means you have to disclose it on the form if the form says it's one of those items. There are additional things, and these become perhaps a little more relevant when there's representation of more than $1,000 for certain work for hire and from businesses that operate in Virginia. In addition, there are payments, honorariums for talks and meetings and publications when they are more than $200 each. Then you get to the gifts and entertainment when it's at a single event of more than $50 in value or a combination of more than $100 in value. Triggering at times, and I put these all up here, and I lost my picture of the coon dog because that also has value, and I'll maybe tell you that dog story when we get a little farther. But there are lots of things that are given to appointed or elected officials as kind of, oh, would you like to have these tickets? Would you like to have the tickets to the Gold Cup? When we got to the Disney project in Prince William, we got tickets to the Lion King opening at the National Zoo. Not necessarily illegal to take those, and we'll get to later on whether or not you should, depending on what the reason is you are getting those tickets. But if you're getting these from people who aren't friends, you're very likely to have to disclose it on your disclosure form. My interlude example, going back to the Lion King tickets, is that they came in and we had hoped that we had an arrangement with the firm that was representing Disney not to tempt appointed elected officials and staff. So please do not tempt. Really respectable attorney on the other side representing Disney goes, okay, fine. But they don't always tell their attorneys what they're doing. So I call up and I go, oh, we got these Lion King tickets coming in. And these are very valuable. At that time, Lion King had just come out, so it's a while ago. Why did they come in? Well, we didn't know that they sent them. Okay, well, all my supervisors said, they're going back? Give them back. We don't want to be tempted. We heard about those people down in Florida, in Kissimmee and otherwise, that got condos from Disney and exotic places. And we don't want to touch that kind of stuff. We're not Florida. Okay, send them all back, except one. One says, I don't know that I really need the tickets, but I really want to go to the event and stand across the street and protest. Is that okay? And the answer was yes, it was okay. And we had some rare personalities at that time on the board, and this particular lady was quite rare. And so yes, she could go, and the tickets, everything else kind of stopped. In fact, it got to the point where they were so good about not doing things to tempt us that at Christmas, they sent Christmas ornaments. And so the Christmas ornaments came in, and they were those styrofoam balls with the laminate around it. You know, you pay maybe 10 cents for them in the store, and they cost half a cent to produce. Well, they sent one to all the members of the Board of Supervisors, the Planning Commission, and everybody shipped them to our office because they didn't even want to touch anything. So at least they'd gotten to close to nominal value. Okay, information that doesn't have to be included on that form. Personal business entertainment. Again, the focus of COIA is on your work and what you are doing with respect to your public body. Gifts from a relative or personal friend. Campaign contributions are exempt. That's because elected officials have to report those on other forms. If you have a personal interest, you have to disclose before acting if it's a matter that allows you to still participate. Have to disclose before in writing and verbally.
Sharon, how did you all do that in Prince William, and what's your advice to jurisdictions as to how to do that?
Well, I think you do it, I call a noisy disclosure. At that time, the law did not require it to be verbal, so there weren't necessarily verbal disclosures. But I sat at my desk and I had a drawer that had a pack of disclosure and disqualification forms in it, so that if I didn't know ahead of time and it came up, I said, here's the form. The best way is to go in and talk to your county or town or city attorney in advance. Say, here's my issue, and then have the form all prepared as opposed to trying to mess up the meeting, which makes it, in some cases, more significant than the issue actually is. So you want to do it in a formal way. You then, before the vote, you say, excuse me, or actually, let me go back. Before the discussion on the item starts is the best time to say, I have a disclosure I want to make here. This is what I want to disclose. This is why I want to disclose it. And then if it's one of those circumstances, and we'll get to it, where you can vote if you can act fairly and objectively in the public interest, you indicate that. We'll get to, if you disqualify, you need to say, here's my disclosure form. I had a separate form. If you're interested in forms on these, I'll be glad to, if you give me a card, I'll be glad to send it to you. That said, same thing, disclosure, why disqualify. The person disqualifies, and depending on the issue, particularly if it may be related to their property only, some of them felt comfortable getting off the dais, because then everybody knew they weren't part of the discussion. You also can't go in and participate in closed meeting if you disqualified. And it's better for those people to stay out of the room than to sit there and try to, remain quiet and not say anything, or say things and then say, well, that didn't really relate to the issue. So my view is noisy disclosure, get it over with, have the forms ready in advance, and then it doesn't become as much of an issue.
That was our practice in Blacksburg. Now, Cecile, you're on the council now. You still do it that way? The mayor read it in at the beginning of the meeting?
Yeah, I've disqualified myself from one issue.
I almost felt, at the time, we had a supervisor who was married to a person who worked for the schools. So every time anything came up with schools, he even sometimes over-disclosed. And so that's why I had my pile there, and they were all ready, and after a while, everybody went, oh, okay, his wife works for the schools. He told us. In another case, we had a more complicated situation in which we had a supervisor who was a quasi-developer and made disclosures, and I guess the public felt like they ought to elect somebody else in the next election. Okay. Now, personal interest of an officer or employee. I've gone through those, $10,000 in income. It's the same sort of things you're going to have as personal interest on the form that has to be filed annually. 3% interest in a business or real estate, and then ownership of property if the interest of real personal property if the interest is over $10,000. Again, remember 3% liability interest, 10% on options. And this piece of legislation came out of Prince William because there was a situation, comp planning issue up in the west end of the county around Gainesville, which some of you may be familiar with now, issues as to on a citizens advisory committee. Some people had options to buy property or had options on their property from people who were coming and presenting before the commission. Okay. Again, remember that personal interest includes other persons in the same household who receive more than half of the financial support.
Household meaning that they live in the house.
Yes, in terms of not any spouse qualifies as personal interest, but the dependents have to live in the house. So if you have children who are married, have gone away, or if you have other people who are family members who have moved outside the house, then and you're not providing that dependency of 10% or more in terms of support. Okay. Putting aside the bribes, which we know are not going to be an issue in your locality, you either, if there's a personal interest, there's either requirement for disclosure, verbally and in writing, or if interest is the person's interest, and I use the word you to be phrased. So you're the only that transaction is going to require just a disqualification. And again, disclosure verbally and in writing. We had some colloquy with Mike about Blacksburg. Actually, if you know the project is coming up, some supervisors would rather say that well before it's even on the agenda, and to file the form so that there is no suggestion that somehow they're doing things under the table until it actually appears on the board agenda. And I think that's kind of prudent to do that way. It's also very, very good politically, I think, to do it. Okay, groups. If the personal interest is the same as that of a group, and that group is defined as 3 or more people, depending on the circumstances, may not have to disclose. If it's 3 or more people and it's a small group, meaning the impact is on less than your entire jurisdiction, then a disclosure, and can vote if the official or the person, let's say you have a piece of property and you're a staff member, and the zoning category is going to be changed in terms of the definition. So you might have a personal interest, depending on how your property is owned. If it's affecting 3 or more people, and I'll call it small group, meaning no broad impact across your jurisdiction, and you can indicate that you can vote fairly and objectively, or you can work on the matter fairly or objectively in the public interest, then you can go ahead and do it once you make the disclosure. If the nature of the change or the issue affects the entire locality, let's say it's a change to the agricultural zone, and you happen to own property that's owned agricultural, then there is no need for a disclosure because it is of broad impact. Now, if you pick a really narrow zoning classification, not single issue zoning, but in some localities there is an attempt to further really define certain important areas, an innovation area, or where there are only a few properties that have that zoning. My view would be that there should be a disclosure either by the planning commission or a particular staff impacted, and then go to the fairly and objectively as opposed to saying, well, it's a text amendment, so I'm not going to be involved. Same thing with respect to the comp plan. I think there's some rule of reason there, and I always believe it's better to over-disclose than it is to under-disclose. Okay, when in doubt, stop. Call. County attorney, Commonwealth's attorney. County attorney can give an opinion that's good evidence if you happen to get charged. Commonwealth's attorney, if you give the precise facts and the Commonwealth's attorney says no violation, then can't be charged. So obviously, county attorney is charged with prosecution, so out the hook. What I've done with the jurisdictions I've worked with is develop a good relationship with the Commonwealth's attorney so that I've given an immediate opinion to the officer or the employee commissioner, and then ask them if they want me to go and ask the Commonwealth's attorney, and then I get an opinion from the Commonwealth's attorney that solidifies that. So that nobody's kind of worried about whether or not they kind of might get charged and have to bring their county attorney or PA to use as good evidence. So you want to lock down the insecurities as much as possible.
What if your Commonwealth attorney is your county attorney?
It's interesting. They may need to write the opinion under their particular title. Let me tell you why. It's a good point. If the county attorney's opinion is confidential, the Commonwealth's attorney's opinion is not confidential. It's a public document. And those of us that do this kind of make sure that you don't unnecessarily get in a public document. Or there's some pretty private matters, like my wife doesn't know about my significant other, but that significant other is a real estate agent who also owns property in this area. And somehow you really want to finesse that. Okay. So you have a conflict. Will you dare to ask before it's too late? It is too late if the matter is up at a planning commission public hearing and you're about to give the staff report and you go, oh, I didn't know that my husband had an interest in Shell Oil Company because he's got a municipal, a set of municipal investments, bonds and stuff, and whatever other, I'm not really done planning in that regard, but he's got this portfolio, and what do? You don't want to sort of say, town attorney, could you answer my question right now? Not good. Or to have a planning commissioner say, oh my gosh, I didn't realize that my son who lives in the household buys most of his fencing material from a company that is before us for conditional use permit. And it's a really good supplier. You don't want to have to sort that out, because then it looks like somebody's not, keeping an eye on the ball. And you can't really, as the attorney, you can't sit up there and go 21 questions trying to figure out the facts. You call a recess and everybody thinks you're outside cutting some deal. Particularly if you come back in and the county attorney's advised that either there's no requirement for disclosure or it's a disclosure that can go fairly objectively, they think you've cooked it somehow and you've lost your credibility. So you don't want to save those questions for the last minute. Particularly, it makes it even worse when your meetings are being videotaped and you say, "Oh, excuse me." You know, one of the commissioners goes, "I just bought like a golden lab from that business which is coming in to get an extension on their SUP for a kennel. Is that a problem?" And everybody out there in the video world goes, "Oh, it's so cute, it's a golden lab." Or they go, "Huh? Not good." And then they think the dog was given to you. Okay, so anyway, call early, often, avoid, and you enhance citizen confidence. And when you do this in an orderly manner, the citizens have more confidence in what you're doing. So the first one is called Shamrock. And Shane Shamrock co-owns a proposed Shamrock in Dakota County. And it's a big deal. This store is going to bring in lots of tax revenue. It's going to make the Board of Supervisors real happy. And we've been shopping this project because you have to do that when you're going to be a big developer. You do a Shamrock. And we've gone around to the various commissioners. And we've given these commissioners some de minimis little trinkets. You know, little keychains that say Shamrock, sometimes the cheapest. And cozies, you know, because they need some cozies for their bottles. The slogan, "Mom and Pop Poo." I just saved a bundle at Shamrock. And of course, those t-shirts saying minimum wage equals no wasteful spending. I know you all been through a budget process recently and you understand that. So I come in and I meet my favorite commissioner, and I'm talking to my favorite commissioner, and I'm giving him some of those little trinkets they're putting in us. I know, you know, my golfing buddy, you know these things ain't worth much, but it's near the end of the day. I know you had a tough day. Here, I bought my bottle of Virginia Gentleman. And can you share a glass with me? It's got the Shamrock logo on it because I have to do that. I can't put that, go around giving out alcohol without the logo.
I'm kind of thirsty.
So we go to scene 2. We're at Chairman for Sales. And Commissioner Sharon for Sales was in real estate business. She wasn't going too good on the residential properties because of the recession, so she's into commercial. And what better commercial than Shamrock's? So being chairman of the planning commission is pretty important. So she's talking to people who come from the planning commission all the time, just citizens. Citizens like all of us, like Ken Dafford, who was the developer. And she says to him, Ken do it, just think of what this Shamrock's going to do for the area. Just think about what it's going to do. And, you know, there's some commercial property near there. I'm sure you know that. It's all on the GIS stuff, but I'm not telling you any secrets, but it's coming up for the planning commission soon. I think I got the votes. Maybe you should talk to some other people. But you know, if you pick up some of those properties and you need to market them, who do you call? Me. I'm a for sale. So she leaves that phone conversation, and she gets a call from Susan Dutz, a dress shop owner. And she's on the phone with Susan. "Oh, Susan, how you doing?" "Oh, Susan, I know you're concerned about your dress shop being run out of town by Shamrock, but don't worry about it. They love local businesses. What you really need, Susan, is a bigger sign on your shop." Susan, Now, honey, don't get too worried. Please calm down. I know you are such a busy person running that dress shop and being on the local sewer and water authority. And we need your help, Susan. I'll keep you in mind as I think about this. I'll keep all of those local businesses in mind. And honey, please get a larger sign for that store. Okay. So we get rid of Susan. Now we go to the home front. Poor Ima has to deal with Stand Firm, her husband, who's just a little crotchety. He owns some land near the Shamrock, but he won't sell. And she's bugging him, and he goes, Ima, I'm tired, I'm not going to sell. That's my granddaddy's property. And I know you're upset because they're not getting any income off that property because, well, frankly, I just don't want to farm anymore. I'm just letting it lay fallow until it gets more fertile. And I know you don't like it because Granddaddy didn't like you. Sometimes I don't either. So you leave me alone, except I want you to take care of that Commissioner Chasenville. I cannot stand it. I watch the video of the planning commission every week because I want to see your lovely face. But I'm tired of that man talking about going to Shamrock in that other county. I'm tired of it. I'm tired. I don't care if he's buying plungers. I don't care if he's buying nails. I don't care if he's buying jeans. Now maybe you can take care of him because you're the chairman. So, we get to Commissioner Doe's son, Junior. Junior needs a job. Junior is a greeter at the Shamrock in the next county. But Junior's gasoline bills are kind of high, so he was on the phone and he's talking to the HR person for the Dakota County Shamrock because they're moving ahead with hiring. And he goes, yeah, I'm good. I can stock, I pump iron, I can do all that stuff fast, and plus I won't have to drive. I can stay in the county. I can use my gas to take those trips to the big city instead of having to use it to go to work. So, do I got the job? And my daddy really would be really happy he's on the planning commission. I got the job. So Junior hangs up and he calls up his aunt. His aunt, May Kay Work, Commissioner Doe's sister-in-law, co-owns part of the new Shamrock. And he goes, Aunt May Kay, I want a job so bad. I want a job so bad at the Shamrock. And I called and I had my interview and they were really nice to me. And they took down my name and address. You think you can get me a job since you co-own the place? Really? A done deal. Great. I am so excited. So Barry gets off the phone. And we get to the lovely Susan Dodson, owner of the local dress shop, who is a little troubled, as we know, about the loss of potential business with this Shamrock. So what does she do? She calls Dakota County Attorney Noah Law and her former boyfriend. She says, no, hon, you know I'm really upset. And you know all this legal stuff. And I think there's something fishy there. I think there are conflicts all over the place. Conflicts with Chairman for Sale and with Commissioner Doe. And that son of his, Junior, I heard he got a job. And his sister-in-law, who owns part of the new property. What's going on here? And it's not like I have any personal concerns here. I care about all the businesses. But I'll be damned if they're going to connect water and sewer. I'm going to vote against that when it comes before the sewer water. So no, honey, can you like tell me? And I keep it real confidential. Right. Okay, so Now it's your turn to play. Kim, Commissioner Devil, accept these tacky trinkets. Any problem with the tacky trinkets? Okay. Participation time. How many people think you can accept the trinkets? Can, hand out, can. Okay, how many say no? Okay, why no?
I don't think you should do it.
Is it a violation of the act? Okay, I think you're right. It's not a violation of the act. If he accepts them because they're kind of like all thrown there, you know, it's like the little sisters of the poor get in front of you, it's new the tune, you just can't go around because they're just I'm Catholic, didn't mean that.
Anybody who sees that.
You may have to, you know, you may feel like you gotta take them, they're probably nominal value, but don't show them around. I mean, I remember a couple of projects that had some character to the name of the applicants, and we'd say even to staff, really, you don't need to have those trinkets sitting out on your bookcases in your office. Take them home, put them away. But it's better to say no, because then we don't have them coming up and asking you later on, oh, I see your keychain's broken, why don't you use the one I gave you?
Shouldn't that question actually be A and B? Can and should?
Yes, it is. The answer is you can legally, it says anything of value. It's hard to say that, we used to talk to our clients and say, what's the value? And they go, don't tell me there's something less than $25. But that's, in some localities have ordinances in that regard, not many. $3, yeah, I mean, in nominal value, it's better, the answer is better not to take them, because then you don't send the message that you're willing to accept them. So the next time when the baseball bat comes in, because Wilson's Sporting Goods is located in your area or whatever else, you don't have to worry about the next coming in with a ski trip. Okay. And they accept the bottle of Virginia Gentleman. Legally.
They take a bottle, they just have a drink.
Ah, yes. One of my colleagues in another locality, some of you actually are from his localities, says if you can consume it all in one decent meal. The attorney had chocolates and other kinds of stuff. Wait a minute. But it was a real problem in Fairfax a long time ago, back in the 60s, I think, or something maybe in Fairfax, where building officials were getting hams and trunks of liquor.
Christmas time.
Yeah, so, not good. A lot of people got indicted. Okay. The servant for sale have a conflict based on her work as a real estate agent in voting whether or not to recommend approval of the Shamrock project.
Yes.
Right, how many say yes? How many say no? Yes, sir. Why do you say no?
Seemed a little bit indirect and not specific as you laid it out there. She doesn't own anything. I mean, if you're asking, does she have a legally enforceable contract?
That's correct. Does she have?
I don't think she does.
I think the gentleman's probably right. There's a lot of smoke around this.
Right.
And it may be and the facts may change very quickly depending on whether she gets involved with that land that's immediately around it, what she's saying to develop or do it. There's a separate issue here from whether or not she has a conflict as in personal interest versus whether she is using her official position to get economic gain. And her conversation with DeWitt is one that should not occur. One might say it's kind of marginal, but when she says at the end, if you want, do business with me, if you're going to sell these properties in the area, my view would be that that's a problem, she shouldn't do that. Yes, sir.
I was just going to say, it seems to me that the key to this is, will she get permission for the sale of the property for the Shamrock? If she will, then she's got a conflict. Or does she directly own any of the land whose value will be increased by the presence of it? And if she does, then she has a conflict.
Right.
If the only situation is that she might possibly be the realtor, who is asked by the owner of the adjacent property to handle it. I don't see that as accountable.
And if it happens after the vote, it's a real dicey thing. And you want to be very careful about it because there's, as I said, there's the personal interest disclosures, then the don't take bribe and the prohibited contacts. And one is if you use confidential information for public gain. If you're using public information, that's, you have to be really careful with that. And that's one where unwittingly applicants or others that are involved in the process in various ways may come to your commissioners and they don't intentionally mean to actually bribe them, but what they say is sets up a potential for the commissioners getting trouble. Yes?
You brought up after the fact. I'm on planning commissions, we have folks that were so pleased to have everything go the way they wanted, that they said, we're going to bring you such and such after the fact. And to me, that's still, it's like taking the bribe, you put something afterwards,
Well, and you need, again, it needs to be very, I would say don't do it even after the fact, but it depends on how it comes up. Because sometimes the world will think that the deal was made before the vote occurred. And you don't want to be, it's an appearance, and that's not a violation, but it's enough to perhaps get the Commonwealth's attorney to charge you. And then you can sift it out in court. Now, we all have a great confidence in the justice system, but there is time there. And in that time period, there is a lot of opportunity for problems. So my view is that, and I think I've had situations where officials have come to me and said, after the fact, I've been made this offer, can I go ahead? That's a wise idea to ask your legal counsel. The other thing I would note that is a potential problem, I'm going to lose my thought process on that, is that when there's a situation that it occurs after the fact and they are given employment. We had a situation, and this is public, so I'm not confidential, years ago where a county executive left county government and then went to work for a very large developer. We had this huge project that was a whole peninsula of land. And after that, the board adopted an ordinance, which you had in county executive form of government, that prohibited certain types of work within a year after leaving. So it's separate from the Conflicts Act. Okay, I've been advised that I'm at 11:15, so I'm going to go down. Just kidding. Go ahead.
If that chairman had sold the property, had been agent for the property, say a year or two before,
Right.
and maybe ShamWow or was it Sham acquired it, would she have to recuse herself? Is she
Probably
in
not,
the
but she
broker or
might.
the agent?
If she already sold it and it's gone, and then the application comes in, the answer is, and she's got all the income. If it's an installment payment of income, then there may be an issue. There are some of those, so, but probably not, but might want to do it anyway, just because, particularly in small areas, but not just small areas, word gets around. So it's better for you to be the one making the disclosure than to have it on the rumor mills, and then you say, well, I just want to disclose now, because everybody thinks the worst. And the public out there doesn't understand the nuances of the Conflicts of Interest Act. They are more looking at the appearance of impropriety. So the issues actually tend to come up earlier from the public on contentious matters, or sometimes it's just somebody who's embittered, former spouse, former boyfriend, former girlfriend, bad business deal. The rumor mill starts. I mean, let's all be human about this and realize that we're dealing not just with the law, but we're dealing with how do we both give integrity in government and at the same time do it in a way that builds that confidence. And then you're not backtracking. Okay. I have a couple more that I'll send to you, but maybe we'll get back to it later. I want to go on to Freedom of Information Act. Can Susan Betts vote on the sewer and water issue with Shamrock?
No.
Because she doesn't like them because they cut out small businesses?
Because she had that bias.
She has bias. Bias is not enough. Bias is not enough. Although I've had that question come up, I am totally opposed to growth. Can I vote on this issue?
I think she can.